Breaking news. Something unprecedented just happened inside the United States Supreme Court, and it's sending shockwaves across the entire nation. A 6-3 ruling has just changed the landscape of concealed carry laws forever. And whether you own a gun, support the Second Amendment, or even fear where this is heading, what you're about to hear will absolutely shake your understanding of American gun rights. Stay right here, because this decision isn't just about carrying a firearm, it's about power, control, and the government's reach into your personal freedom. Now, before we dive deep into the full breakdown of this shocking Supreme Court ruling, do me a quick favor. Hit that like button and subscribe right now if you care about staying informed, because YouTube's algorithm doesn't show this kind of content to everyone. It only spreads when people like you interact. By subscribing, you're helping this message reach thousands of other Americans who deserve to know the truth about what's unfolding behind closed doors. Now, back to the ruling. This isn't some minor adjustment or legal technicality. We're talking about a radical reinterpretation of what concealed carry means under the Constitution. And for millions of lawful gun owners, the consequences could be massive. States that once granted wide discretion to issue carry permits might now be forced to comply with new federal standards. Others could see their laws completely overturned in the coming months. And the way this decision was worded, that's what's sparking the most outrage and confusion. Even some conservative justices express concern about how broad the majority opinion truly is. Was this a victory for freedom, or a silent trap that could restrict gun ownership in ways we don't yet understand? We'll uncover every detail, including the political motivations that could be lurking beneath this decision, and trust me, it's not what the media is telling you. So make sure you watch until the very end, because the final revelation in this case is something no one expected, and it could change how every American views their right to self-defense. And when we get there, I want you to drop a comment below and tell me, what part of this ruling shocked you the most? Was it the vote split, the language used by the majority, or the implications for your own state? Let's talk about it, because this is more than a headline. It's the beginning of a new chapter in America's gun rights battle, and the end might look very different from what anyone predicted. Listen up, the Supreme Court just dropped a bombshell decision that may redefine what it means to carry a firearm in public. A 6-3 ruling has fractured decades of legal norms, ignited fierce debate, and sent gun owners, state governments, and courts scrambling for clarity. This is not a small tweak. This could be a legal earthquake that changes concealed carry across America. You're going to want to stay with me all the way through, because the final revelation is something that even constitutional lawyers are still digesting, and it will absolutely shake your perspective. Before we dive in, make sure you smash that like and hit subscribe if you care about understanding your rights, because YouTube will only push this content further when it sees engagement. Your subscription helps break through algorithmic walls so that more people can see what's really going on. Also, comment below what part of this ruling shocked you most: the vote, the logic, the state impacts. Let's start the conversation. Now, here are the 6 critical pillars you must understand. 1. The Bruen decision. A new constitutional test emerges. This landmark case, New York State Rifle and Pistol Association versus Bruen, decided June 23, 2022, is the heart of this shift. In a 6-3 opinion authored by Justice Clarence Thomas, the court overturned New York's proper cause requirement for concealed carry permits. That is, the idea that you had to show a special reason beyond general self-defense to carry in public. That requirement was deemed incompatible with the Second and 14th Amendments. The court replaced the old balancing approach, weighing public safety versus rights, with a history and tradition framework. If the Second Amendment's text covers your conduct, the government must justify its regulation by showing consistency with historical analogs. Any law that cannot be traced to historical firearm regulation traditions is presumptively unconstitutional. This overturns decades of intermediate scrutiny approaches. Because of Bruen, state laws in California, New Jersey, Massachusetts, and others that use discretionary may issue models or proper cause systems are now legally vulnerable. Courts are already striking down restrictions across the country. 2. Immediate fallout. States and courts rattled. Within months and years of Bruen, a cascade of rulings struck down state and local gun restrictions. Judges in California have invalidated broad bans on carrying in many public spaces. In Illinois, courts ruled that transit bans on concealed carry violate the new standard. Maryland's restrictive concealed carry regime faced immediate legal threats as well. Some courts interpret Bruen very aggressively, requiring state laws to find 19th century analogs for any restriction they want to survive. That's 4 states to scramble to defend modern policing goals through arcane historical research. Meanwhile, gun rights advocates are filing a wave of lawsuits challenging age limits, bans on ghost guns, magazine capacity limits, laws preventing guns in sensitive places, and more. One of the latest frontiers. The Supreme Court has just agreed to hear a case about restrictions on carrying handguns on private property open to the public, like restaurants, stores, malls, in Hawaii. That case could further expand how far Bruen's influence spreads. Washington, D.C. is reacting too. The U.S. Attorney in D.C. announced that registered rifle and shotgun owners would no longer face felony prosecution for carrying, citing conflicts with recent Supreme Court precedent. That's a radical local policy shift driven directly by the new jurisprudence. The legal landscape is in flux. Some states will adapt, others may resist, and chaos is likely until new precedent solidifies. But Bruen unleashed a wave that cannot be easily contained. 6 conservative votes, but internal disagreements and tensions. While the ruling passed 6-3 along ideological lines, it was far from monolithic. Justice Kavanaugh, joined by Chief Roberts, wrote a concurrence explaining that states still retain the ability to impose licensing requirements, e.g. background checks, training, non-discretionary objective criteria, so long as those requirements align with history. That means the door is still open for reasonable regulations, but they must be tethered to historical analogs. Meanwhile, some of the conservative justices have expressed caution about how radical the majority's historical inquiry could be in future cases. They know courts will now be asked to become reluctant historians, matching modern regulations to 18th or 19th century laws. Lower courts are already struggling with those methodological challenges. While gun rights advocates celebrate. Inside the court, there is tension. How far should modern regulation bend to historical forms, and to what extent should public safety or technological evolution be considered at all? This tension is likely to produce future fractures, particularly when novel issues, like bans on high-capacity magazines or assault weapons, hit the docket. 4. The 21st century conundrum. Sensitive places, modern weapons, and regulatory gaps. Bruen expressly preserved the idea that sensitive places, such as schools, government buildings, courts might still be off-limits for guns. But the decision didn't define sensitive places, leaving ambiguity. That has prompted a flood of litigation over whether parks, stadiums, public transit, hospitals, places of worship, or polling locations qualify. States will now try to defend bans in those spaces via historical analogs, e.g. 19th century bans on firearms near capitals or courts. Whether modern mass transit hubs count is contentious. Likewise, the court reaffirmed that long-standing prohibitions on felons, the mentally ill, and laws regulating the commercial sale of arms remain intact. But new questions loom. Do bans on ghost guns or 3D printed weapons measure up historically? What about magazine capacity limits, bump stocks, devices that simulate fully automatic fire, or assault-style weapons? Some decisions go one way. In 2024, a 6-3 ruling struck down the federal ban on bump stocks, reasoning that they did not legally qualify as machine guns under statute. Other restrictions remain under legal fire. For example, Maryland's ban on military-style assault weapons was recently upheld by a federal appeals court, signaling that not every restriction will be overturned, particularly if states can tie them to historical regulation. In short, modern weapons and infrastructure may not fit neatly into 19th century analogies, but the court has opened the door to challenge nearly every dimension of gun law. 5. Political and social blowback. violence, health, and polarization, that IT wasn't just legal experts who reacted. Public health organizations, state officials, and gun control advocates immediately condemned the ruling. The American Medical Association called the decision harmful and disturbing, warning that easier access to firearms and fewer restrictions could exacerbate gun violence. Advocates point to the tens of thousands of firearm deaths per year in the U.S. as evidence that states must retain latitude to regulate. The dissenters in Bruen echoed that, arguing that courts must consider empirical data on violence, not just historical precedent. In states with restrictive gun regimes, lawmakers now face huge pressure to rewrite or defend their systems. Some will likely craft narrower, objectively justified licensing schemes tied to self-defense, training, and discrete categories. Others may double down on broader prohibitions, e.g. on assault weapons or certain public zones, hoping to defend them under successor litigation at the national level. Some Democrats and gun control advocates are pushing for new federal legislation to fill perceived gaps, e.g. universal background checks, red flag laws, or bans on accessories. But with the new Bruen standard, any such regulation must survive historical scrutiny, meaning Congress faces a narrower, more dangerous path forward. Polarization will intensify. In many states, court rulings will force elected officials to rapidly respond or face backlash. For citizens, owners, law enforcement, and victims advocates, the rule of law itself is now under contested terrain. 6. The hidden twist you can't miss. The real risk isn't expansion, it's legal chaos. Here's the final bombshell. I promise the real surprise isn't just greater freedom. It's legal chaos and unequal access. Because Bruen depends on historical analogs, lower courts will interpret it inconsistently. In some circuits, states may see near total deregulation. In others, courts may adopt narrow, cautious interpretations that preserve many restrictions. So your rights may depend entirely on your circuit and district judge. Moreover, defending modern gun laws now requires states to dig into centuries-old statutes, often written in archaic language. That means states lacking legal resources may fail, while well-funded challengers succeed, producing inequitable outcomes across states. Some people will be advantaged by fast judicial wins. Others will be left behind. Even more ominous, this ruling invites preemptive lobbying and regulation, as legislatures rush to craft statutes that sound historical or reference old laws regardless of efficacy. That means legalists and historians could wield more power than medical experts or violence data. Finally, because so many regulations are now vulnerable, we will likely see mass litigation, everything from bans on high-capacity magazines, restrictions on guns in universities, laws governing open carry, limits on minors owning firearms, and even municipal-level bans will be tested. The courts will be flooded. Some rulings will be coherent. Many will be contradictory. This could fracture national gun jurisprudence for a decade or more. The bottom line, this 6-3 decision didn't just change concealed carry law, it rewrote the rules of engagement for every gun regulation in America. And until higher courts clarify, the battle will be fought case by case, state by state, circuit by circuit. Oh, there you have it, 6 brutal realities forged by this 6-3 Supreme Court ruling. The new Bruen test, the court of fallout, fractures among the justices, showdown challenges over modern weapons and spaces, political backlash, and the looming chaos that lies ahead. But here's what I want you to do right now. Comment down below, which one of those 6 topics surprised you the most? Was it the legal uncertainty, the historical test, or the ripple in state laws? I want to hear your take. If you stayed this far, thank you, but don't leave yet. The next video I post will dive deep into one of those sub-issues: magazine bans, ghost guns, assault weapons, and that final revelation will absolutely shock you about how far the court might go. Don't forget, like, subscribe, and engage. Your action ensures that more people see what's really unfolding behind closed doors. Let's keep watching, keep questioning, and never let them decide without us.